Okay, so before we start chapter 7, we discussed in chapter 6 4 elements that will form a valid contract. We discussed 2 of them. I showed you the 4 elements, but we discussed 2 of them. What are the 2 of them we discussed in chapter 6 that will form a valid contract? Yes, consensus and consideration. What is consensus comprised of?
Parties made the decision collectively. They
Okay.
know what they're agreeing to.
Yeah, so parties meet their mind, but we saw details of 2 aspects in consensus. Consensus is comprised of one thing and another thing. So 2 things we saw in consensus in more details. Offer and acceptance. Very good. So consensus is made of a valid offer. Offer has to be valid. Cannot be an invitation to treat. It has to be an offer. It has to be valid. It has to be in time. And effective acceptance. So acceptance has to be effective, has to be communicated, has to be unconditional. So this will form consensus, the meaning of the mind. And then we also saw consideration. What is consideration? Yes, mutual benefits for both parties. If the coffee is my benefit, the coffee is also the price of the other party. If the money is my price, the money becomes the benefit of the other party. So that's why we define consideration as either mutual benefit or mutual price to be paid. So those 2 ingredients for a valid contract. Today we'll see capacity, and I told you that capacity is actually not a required element. There are some circumstances in which a contract will be void, depending on the party, but in most situations, whether the party has capacity or not, the contract will be voidable, not void. And then we'll look at legality and intention. So we'll see that the requirements today are more straightforward, are not too difficult at all. So let's start with capacity. Why is capacity important in contract? Well, the law understands that some parties are more vulnerable than the others. So when you were 5 years old and you entered a contract, now you are 20, 30, let's say 20 years old. Would you agree that your mind, your experience, your maturity, level of maturity is different now, 20 years old, as opposed to 5 years old? Right? So minors, for example, they have limited capacity to contract. What if you are drunk? Would you agree that when you are intoxicated or when you're drunk, your capacity to contract is also affected? You are not sure whether you're doing good bargain or not. So this is what we'll look at capacity. We'll look at some parties that are theoretically more vulnerable, hence they will receive special protection. And their capacity or their ability to contract will be either limited or eliminated completely. So let's first look at minors, infants. We've discussed this already. What is the age of majority in BC? 19. What is the age of majority in Ontario? 18. So age of majority varies from province to province. We're focusing in BC. So if you have a question in your exam, a minor is anyone under the age of 90. Okay, so BC is our focus here. So minors that enter into a contract, guess what? They are not bound by the contract. They may comply with their obligations, but they are not bound. In other words, if I sell a smartphone to a minor, and then I deliver the smartphone right away, but payment, I will get the payment only 1 week from now. So if the minor doesn't pay me, can I sue them successfully? I cannot, because they are not bound by the agreement. So minors are protected. They will be bound by agreements with regards to a loan, student loan, or contract of employment. So those two specific contracts are binding on minors, but any others will not. I am not saying the minor will not comply with their obligations. I'm just saying that if they don't, the other party, the adult or the company, they cannot pursue the minor in courts because it's not binding. So in a similar situation, now that you learned this, now that you learned that minors are not bound by contracts in general, except student loan and contracts of employment, in a similar situation, selling a smartphone to a minor, what would you do to avoid your risks of not being paid? Require ID? And then if you see their ID that they are a minor, what would you do? Bring the parents along? Could be, but then the parents would function as guarantors, but could be, it's an option.
Or decline to sell.
Decline to sell, okay, so you don't sell to a minor, or you have the minor bring their parents or legal guardians to sign together. What else can you do? Did I tell you that the contract is illegal or void? It's not an illegal contract. I told you that the contract is not binding. So if the contract is not illegal, not invalid, what if you require the minor to comply with their obligations right away? I'll give you the smartphone. Let's say you are a minor. If you pay me right away, it's a legal contract. Even though you're not bound by the contract, you have no performance, no obligations after the exchange. Does it make sense? So that's the good point. On a legal risk perspective, by knowing that minors are not bound by agreements, we should avoid entering into contracts with them where their performance is after you completed your part of the bargain. It should be at the same time. Is this clear? So that's how we avoid. If a minor becomes an adult, turns to 19, then, and they continue in the contract, let's say they have signed up for a membership at a gym club when they were 19, and then after they turn 19, they continue going to the gym club. So they are ratifying, they are confirming the contract. In this situation, the contract becomes binding because they keep on performing the obligation. So, are parents responsible for the children's contracts or the minors' contracts? Look at the slides. What is the slide saying? Parents are not liable for the minors' contracts. If my daughter purchased something this morning, and if she doesn't pay, I'm not liable. Unless I had signed the contract with her. So your recommendation. So if parents or legal guardians sign the contract with the minors, then the parents will be guarantors. Parents will be guaranteeing the transaction of the minor. What happens is, as a guarantor, if the minor defaults, then the other party can go after the parents or the legal guardians. And guarantees. So remember I told you last week, contracts, verbal contracts are valid, as valid as written ones. But some types of contracts, they have to be in writing. One example is a guarantee. So what this means is, if you are the owner of a gym club, and the minor comes to sign up as a member, because you learned this, you will say, hey, please go back home, bring your parents or your legal guardians with you to sign the contract. If the minor says, hey, can I call them? And they will confirm it to you, will you accept? Why not? It has to be in writing. The guarantee has to be in writing. So a phone call is not enough. Are we good? All right. So with regards to torts, are parents liable for the torts, for the wrongful conducts of their children? Chapters 4 and 5. Don't remember, I'll let you know. Yes, they are. Parents are liable for their children's torts. There's the Liability Act in BC, there's the School Premises Act. Yes, parents are liable for their children's torts. But again, they are not liable for the minor's contracts. There's a limitation with regards to suing in tort and suing in contract. So because parties know they cannot sue the minor under contract, they try to sue under tort. But if the tort is related to a breach of contract, parties cannot be successful. They can only be successful if the tort is separate from the breach of contract. So here my example is, minor rents a car, and the rental agreement says that they cannot drive in the US. So the minor breaches the agreement and goes to Seattle. The minor is involved in an accident, car accident. So there's a tort. But the minor breached the agreement. So the rental company cannot sue the minor because there's a breach of contract. And minors are not bound by the contract. Now a similar example, but the minor does not drive to the US. The minor is driving in the lower mainland within Canada, and the minor causes a car accident. Now there's no breach of contract, there's a separate tort. Now the rental car company can sue the minor successfully under tort. Okay, so if there's a breach of contract, minor cannot be sued, even if there's a tortious action. But if there's no breach of contract and a tortious action, a wrongful conduct, then the minor can be sued. Are we good? So this is the limitation for minors. Now, with regards to insanity and drunkenness, intoxication. So the rules are the same. That's why they are together here. What happens if you are intoxicated, or anyone who is intoxicated or insane? When they enter into an agreement, if they prove they were intoxicated, but also that the other person knew or should have known they were intoxicated, then they may get away from the contract. Attention, it's not enough to prove that you were intoxicated. You also have to prove that the other party knew or should have known. Because if they did not know, if they should have not known because you were not behaving as such, they would not be taking advantage of you. They thought you would be okay. But because they know you are drunk, you are intoxicated, you are insane, then they take advantage of you. Then the contract may be void. You may be able to get away. Again, you have to establish you had no understanding of the contract. In other words, you were either insane or intoxicated, and the other person knew or should have known. This is very important. So other parties in which capacity is of concern to us. Corporations. So we'll see corporations next week. So a corporation, the shareholders, when they create a corporation or the directors, they may limit the capacity of the corporation. So let's say my wife and I, we are shareholders of a company, and we don't want the company to do business with the government for whatever reasons. So in the internal company documents, we can limit this. So it means that our corporation has limited contracting capacity. It is not uncommon that when investors make investments in startups, one of their requests is that the corporation does not get into a debt, get a loan, over a certain amount without shareholders' agreement. So this is also a limitation. Because in principle, a company has full capacity to enter into any agreements. But shareholders or even directors, they may limit the capacity of the corporation. Because it's possible to request for a corporate's internal documents, a copy of them, but that's not so common. So instead of requesting the documents, lawyers, they usually have in contracts with corporations, they usually have a clause or a section in which the corporation is representing, the person that is signing, the authorized signatory, is representing that the corporation has power to enter into that contract. So they are representing. If that representation is a lie, then it's going to be misrepresentation. We'll see in chapter 8. So corporations, they may have their capacity affected. Crown bodies, governmental companies. So we have to look at the legislation or regulation. We have to look at the law that creates that crown body, that creates the governmental company, to assess whether there's a limitation or not in that corporation to enter into agreement. Okay? Another one. So those only for information. And with regards to the Indian Act, we're going to see more details in chapter 14. So question for you with regards to capacity. Which one? B? Do you all agree? Who agrees with B? Do you have any other? Yeah, this is memorization question. So I told you that for loans, minors are bound. Exactly. So loans and contract of employment. So B is the right answer. All others, the minor or the infant, they are not bound. Again, it does not mean the contract is illegal, is void. It just means that the minor is not bound. Okay, if needed, the other party cannot pursue the minor. So let me give you another example, or let me tell you this, clarify this other part. So let's say in the example that I sold a smartphone to a minor, I got payment right away, but the smartphone was defective. Can the minor sue me?
Yeah,
What do you think?
because they pay.
Okay, they paid, or let's say they didn't pay. Can they sue me? Yes, they can. The contract is not binding on the minor, but it's binding on the adult. It's binding on the other party. So regardless if they had paid or not, they could sue me if the smartphone was defective. Here, that's also important. So now let's talk about contracts performed illegally and formed illegally. I'm going to start with formed illegally, contracts that are formed in an illegal way. This is straightforward. Well, the contract is illegal. Why? Because the object of the contract is illegal. So in those cases, courts will not help. Courts will not help saying that if you enter into an illegal contract and you paid money, you lost your money. You cannot sue. So last Saturday, my friends and I were in a party. We ordered cocaine. Cocaine was of bad quality. So my friends wanted to sue the drug dealer. What did I tell my friends? Hey, this is an illegal contract. We can't sue them. Courts will not help. Here, some examples here. Contracts to commit a crime. Another one. I don't like my neighbor. That's an example. I don't like my neighbor, so I hire a killer to kill my neighbor. The contract terms are, I'll make a down payment, 50%. After my neighbor is killed, I'll pay the balance. So I made the down payment, 50%. My neighbor was killed. Then I remember about this lecture, and I decided not to pay the balance to the killer. Can the killer sue me? No. Yes, the killer can kill me, but they cannot sue me, right? Because it's an illegal contract. Contracts to fix prices. So let's say all coffee shops here at PCAT, not all, but most of them, they agree to set the price of coffee for $1 because they want the other coffee shops to shut down, because the other ones are selling for 2, 3, 4, because the majority will be selling by 1, so no one will buy coffee in this other coffee shop. This agreement to set price, to fix price, is illegal, also known in competition law as cartel. Okay, gas stations. If gas stations get together to set the price, one price, if they have an agreement, this is an illegal agreement as well. So, straightforward, an illegal contract, a formed illegal contract, is the one in which the object is illegal. Is this clear? And courts will not help. So if you sue, courts will say, no, I cannot take this lawsuit because it was a formed illegal contract. But now we also have the performed illegal contract. So it is a legal contract in which performance will be illegal. The contract is legal, but performance will be illegal. Is anyone a doctor here? No? I'm not a doctor either. So let's say you hire me for medical services. Is a medical service agreement legal? Yes, it is. Can I perform medical services? No, I cannot. I'm not a doctor. So the contract is legal, but performance will be illegal. In those cases, yes, courts will help the parties. So if you hire me for doctor services, and my doctor services will be illegal performance to you, then you can sue me to get your money back. Okay? And there's also a situation in which the legal performance is temporary, is not so serious. My example here is the construction. So you hire my company, my construction company, to have your house built, and I start construction without the building permits. So it means I'm performing the contract illegally. But very soon I can obtain the building permit. So I can correct that situation. In those cases, courts, they will not cancel the contract. They will keep the contract alive, and they will order the party to correct the contract, their performance. But in the first example, the medical services, I have to go through 6, 8, 10 years of study to become a doctor. So it's virtually impossible to make that illegal performance legal. Okay? In those cases, courts will cancel the contract, make it void, and restore the parties to their original position. So original position is the party who had a loss, they will recover the loss. Are we good? So with regards to illegality as an ingredient for a valid contract, we have two types of illegality. We have performance as illegal, and we have formation as illegal. And the situations, they differ, consequences differ. Okay? So before we go to a question, we also look at restrictive covenants. So those are sections in an agreement in which one party is preventing the other from doing something. And it's usually related to confidentiality, not disclosing confidential information. Non-solicitation, non-soliciting on former employees, former suppliers, former clients, and non-competition, non-competing with them. So those are examples of restrictive covenants. We will discuss them again in the employment section, in employment chapter. But now I'll keep my explanation and example to a business situation. So let's say you have a pet shop and I am purchasing the pet shop from you. Would you agree that as a buyer, I don't want you to compete with me after you sell your pet shop to me? Do you think it makes sense? What if I allow you to compete with me? Will you not get all the clients because the clients are yours? So if you sell it to me and then next door you start another pet shop, the clients from the pet shop that I purchased, most of them, they will go to you. So I will purchase your pet shop if you agree not to compete with me. Not forever, for some time, within some geographic limitation. In employment agreements, and we'll discuss in more details, it's similar. Companies, they may not want employees to compete with them after they leave. This non-competition for employment specifically, it is now prohibited in Ontario, and it may become prohibited everywhere else. But I'll talk about employment situations 2 or 3 weeks from now. 2 weeks from now. For now, let's give this business example. So, as a seller of a pet shop, I don't want you to start your own pet shop at least in 1 year after the sale date. Not in the area. Let's say I'm purchasing your pet shop here in Central Burnaby. You may start your own in, I don't know, north, maybe south, but not here, not central. Also, for some time, for some reasonable time. I don't want you to be calling on your former employees, former suppliers, former clients to go to your new pet shop. If you want to do this, I'm not buying. So are those restrictions allowed? Yes, they are. They are under this restrictive covenants. So I am limiting your ability to either compete, solicit, or disclose confidential information. And again, they are possible when the limitation, the time limit, and the geographic limit, when they are reasonable. So I cannot agree, you cannot agree to be out of the market as a pet shop owner forever. No, for some reasonable time. Let's say 1 year, 2 years, maybe, I don't know. And again, not in Lower Mainland, not in BC. No, this is not reasonable. It has to be within the neighborhood. Usually. Does it make sense? Whether the restrictive covenant is valid or not, whether it is reasonable or not, lies on the party that benefits from those restrictive covenants. In other words, the burden of proof is on the party that benefits, usually on the buyer. So I am buying the pet shop from you. You cannot compete. You cannot solicit. So if you challenge this in court, if you say, hey, judge, the time limit is not reasonable because it says 10 years, it's too much, or geographic limitation is too wide. You as a seller, you can challenge this, and I as a buyer, I have the burden of proof that this is reasonable. Okay, because I am the one benefiting from those restrictions. You are restricted for my benefit. Is this clear? So those are restrictive covenants. We'll say this again in employment relationships and also property law in the future. Now, intention, the last required element. So intention is straightforward. In business transactions, there's a presumption of intention. So it's not an issue. When you buy coffee, it's presumed that there's intention. So it's not an issue. There may be an issue with consensus, with consideration, maybe capacity if you're a minor, and could be legality, but coffee is legal, so, but not intention. The issue with intention is with regards to social or domestic relationships. Because in those relationships, there's a presumption of no intention. What is a social relationship? Best example will be client and professional. Could also be a church leader, church goer. Could be an instructor and their students. So those are social relationships in which one usually enjoys trust from the others. Don't you agree? Don't you trust your family doctor? Don't you trust your accountant? Don't you trust your lawyer? So there's trust. Because of this trust, whenever you are in business with them, there's a presumption of no intention. And a family relationship, domestic relationship, is parents and children, grandparents and grandchildren, uncles, aunties, and their nieces, nephews, or so family relationships. In those, there's also a presumption of no intention. But attention to this. there's a presumption of no intention. But parties, they may refute this presumption. They may set aside this presumption. Because if I cannot set aside, then I would be saying that in all domestic or social relationships, there's no intention. But this is not what I'm saying. I'm saying that there is a presumption. If parties do not show otherwise, the presumption will stand. How can you set aside, how can you strike out this presumption? Well, what this presumption is saying is, if I sell my car to my daughter, I am abusing on my trust, I am abusing on the trust she has for me. How can I set this presumption aside? Well, if I show in court, if needed be, that my daughter actually needed a car, that she paid a fair market value for the car, and that she had an opportunity to seek independent legal advice, I would be rebuting this presumption. I would be setting this aside. And there would be intention in this agreement. From a legal risk perspective, if you are buying something from your family members, you should remember this. If you're buying something from your father, mother, legal guardian, grandparents. But then you could ask, well, but who would challenge this agreement in court? You may have a cousin. Your cousin is not happy that you purchased your grandparents' old collectible car. And they may bring that contract to court because they may say you abused on their trust. So to avoid this, you should go through those steps. Fair market value, independent legal advice. So you rebut this presumption. This is very important as well. Question for you. Which one? E? E is the legal contract. You agree? Lawyer agrees to represent an accused. Isn't an accused a client? A contract to represent a client. Is this a legal contract or any legal contract? It's legal. It's a legal service contract. It's a legal contract. That's right. E is correct. Regardless if the accused committed a crime or not. This is something different. This is whether the accused committed the crime or not will be dealt with in court. But everyone has a right to have a lawyer, to be represented by a lawyer. Why is this illegal? Defamation, yes. So a contract to commit a tort is illegal. Tort or crime. Why is this illegal? The subject is illegal. Cocaine. Prostitution, sexual favors. Illegal. Contract between camera dealers, they agree not to sell a specific model below a specified price. This is cartel, fixing prices. This is also illegal. So this one is legal. Is this clear? E, right answer. All right, now let's talk about the form of the contract. Also simple. I told you initially that verbal contracts are legal. Verbal contracts are as legal as written ones. However, some specific types of transactions, some limited types of transactions, they have to be in writing. What is the one that has to be in writing that I told you some minutes ago?
Guarantee.
Which one?
Guarantee.
Guarantee. So guarantee contracts, they have to be in writing. Another one is transfer of land. So when you buy an apartment, when you buy a condo, when you buy a house, it has to be in writing. But it may be that you don't have a writing or written contract, but you may have a written piece. You could have, could be the receipt, could be a note, could be an email. Any written piece is fine. So let's say before class, we were having lunch, and during lunch, we decided to come into a transaction for you to buy my house. So we had a napkin. In the napkin, we wrote the address, full address of the house, price, closing date, signature, it's fine. Actually, I had a student who saw this, and for our surprise, the napkin was even dirty. Had been used by the parties. But it was a valid contract, is in writing. See? So you have to keep that in mind. Some specific types of contracts, they require a written piece. Some. The general rule is that verbal agreements are legal. Okay? Well, if the contract is not in writing or there's no written part, the contract is still legal, but courts will not enforce the contract. So if I sell my condo to you only verbally, it's a legal contract, but courts will not enforce. If I cannot go to courts, what other type of dispute resolution I could use? Arbitration, mediation, negotiation. But only if there's agreement, because remember, parties need to agree to go through any of those. Okay. Well, one last thing is partial performance. So I just told you that if the contract is missing the written part, courts will not enforce. However, if there's partial performance, then courts will enforce. So you purchase my lot, verbal agreement. Okay, don't be mad at me. So you purchase my lot, verbal agreement. Now, I am breaching the agreement. You cannot sue me because it was verbal, should have been in writing. However, you can establish in court that I have partially performed the agreement. Let's say I have already put fences in the lot. There's partial performance. I have made a transfer. So if I can show partial performance on any side, then I can waive the written requirement. This is what this is for partial performance. So this is a summary of contract formation. You will remember that if there's no consensus, there's no contract. Contract is void. No consideration, no contract. No capacity, sometimes there's no contract, void, such as insane, intoxication, but for infants, for example, the contract is voidable, not void. There's a contract, but it's not binding on the minor. Illegal contract, void. Illegal subject matter, no intention, also void. Remember the presumptions. We got to be cautious here. And no writing. It's a valid contract, but not enforceable in courts. but some specific contracts, not all. The general rule is that writing is not required. Easy, true or false? False. Is this clear? All right.